Carolyn Maloney was a beloved member of the community. Her murder sent a shockwave through Colleton County. It was an outrage that demanded justice. The lifelong Colleton County resident was a mother to 4, 3 daughters and 1 son, and a grandmother to 8. Carolyn Maloney was the co-owner of Maloney Concrete in partnership with her son. She volunteered for Habitat for Humanity and was an active member of the Canaan Baptist Church in Round O. In tribute to her legacy, a plaque memorializing Mrs. Maloney was ceremoniously hung on the wall of Ruffin High School as the family she left behind looked on. A member of the class of 1967, Mrs. Maloney was a long-standing member of the reunion committee who treasured the friendship of classmates. At Ruffin Middle School, a fundraiser was held in her memory to provide for the installation of central heat and air in the gymnasium. So her violent death during what members of law enforcement called a robbery gone wrong was altogether unbelievable, inexplicable. A criminal investigation got underway immediately in search of answers to the questions troubling the hearts and minds of the community members. The Colleton County Sheriff's Office took the lead with assistance from the South Carolina Law Enforcement Division Forensic Team. Almost 2 weeks after Mrs. Maloney was murdered, the Sheriff's Office offered a $2,500 award for information leading to the arrest of the person responsible for the crime. The day after the award was announced in the newspaper, 4 suspects were arrested and charged. Former Sheriff Alan Beach told the Press and Standard the community was very helpful and supportive during the investigation into the murder of Carolyn Maloney. He said that was largely due to the character and reputation of Mrs. Maloney and her standing in the community.
The targeted act of violence that ended Mrs. Maloney's life occurred late on the morning of Tuesday, April 13, 2004, in Walterboro, South Carolina. Rainy weather created a day off for construction workers like those employed by Maloney Concrete. Carolyn Maloney was in the office of the Acorn Road business, babysitting 2 of her youngest grandchildren. Because of the rain, no one else was there. Her daughter, Carol Mabel, had dropped them off and would be returning shortly with lunch. According to investigators, sometime between 11 a.m. and noon, a person or persons entered Maloney Concrete, intending to commit robbery. They went into the office and fired 1 fatal shot, killing Mrs. Maloney. When Carol Mabel returned to Maloney Concrete with lunch, she discovered the unthinkable. She found her mother dead, her babies covered in blood but unharmed. Mrs. Maloney was sitting in a chair with the 20-month-old child on her lap. The 5-month-old baby was at her feet. 15 days later, 4 suspects were arrested and charged with armed robbery and murder in the case. The suspects were April Hampton, Ray Nelson, Anthony T. Brown, and Anthony L. Brown. For the most part, the suspects gave wildly different accounts of their activities on the day of the murder, accounts that varied from one interview to the next. Adding another layer of confusion to the case, 2 of the suspects had the same name. April Hampton and Anthony T. Brown gave self-incriminating statements. Shoe prints put April Hampton at the scene. Tire treads matched Ray Nelson's car. A weapon was surrendered by Anthony T. Brown. A flowered purse was seized at the home of Anthony L. Brown's grandmother. Other items said to have been stolen from the scene were located as search warrants were executed at the suspects' homes. Within 3 months, all 4 suspects were indicted by the solicitor from the 14th Circuit on charges of armed robbery and murder. All 4 would plead guilty to armed robbery. 3 of the suspects' murder indictments were not prosecuted at the discretion of the solicitor's office. 3 years later, when the charges were headed to trial, Judge Carmen T. Mullen accepted 3 guilty pleas for the armed robbery in which Mrs. Maloney was shot and killed. Mullen dispensed sentences of 20 years to Ray Nelson, 25 years to April Hampton, and 30 years to Anthony T. Brown. Anthony L. Brown entered a plea of guilty to murder and armed robbery and received a sentence of 40 years in SCDC, 40 years for murder and 30 years for armed robbery, to run concurrently. All subsequent appeals involving the 4 have been dismissed without any alteration or reduction of sentence. So it was that justice was served. Or was it?
Almost halfway through his 40-year murder sentence, Anthony L. Brown is applying to the Innocence Project for help with his case. The Innocence Project is a nonprofit organization that provides expert legal representation free of charge for people who have been wrongfully convicted. Anthony L. Brown recently shared his Innocence Project application with FITSNews. He applied in October of 2022, and his case is still under review. He does not yet know if his application will be accepted or when he can expect a decision. Since the founding of the Innocence Project in 1992, the organization has received 65,600 requests for assistance from inmates, and each one is read and reviewed. So the application process is a lengthy one. According to the Innocence Project website, between 2.3 and 5% of all prisoners in the United States are not guilty of the crimes for which they were sentenced. If only 1% of all prisoners are innocent, that would mean more than 20,000 innocent people are in prison. The Innocence Project website also notes that most felony convictions do not come about as a result of a jury trial. 95% are the result of a plea deal. In Brown's application, he contends he is not guilty of the murder of Carolyn Maloney or the armed robbery of Maloney Concrete. With the one exception of his plea change and sentencing hearing, this is what he has been saying all along as his case made its way through the system and as he exhausted the legal remedies available for appealing the sentence without success. His sentence is to be served day for day. In the parlance of jail math, that means Brown is not eligible for early release based on parole or good time, or any other calculation. His exit date is April 18, 2044. In 2004, Anthony L. Brown was a short-term employee of Maloney Concrete. He worked there for about 1 month. His time of employment ended about 3 weeks prior to the murder when he quit to take other employment painting Rose's department store, another job for which rainy days are days off. Anthony L. Brown was familiar to the members of law enforcement in Walterboro and Colleton County. As a juvenile, he had a couple of run-ins with the law. In 2003, at the age of 21, he was charged with assault and battery. At trial, the jury found him not guilty. 6 months later, the Colleton County Sheriff's Office arrested 2 Anthony Browns and charged them both with the murder of Carolyn Maloney. Anthony L. Brown's murder trial was set to begin in July of 2007. The jury had been seated when his defense attorney came to him with a last-minute plea deal and a warning. Public sentiment was strongly in favor of a conviction and justice for Mrs. Maloney's murder. The 3 co-defendants had taken plea deals on condition of their willingness to testify against him. Fearing the death penalty or life in prison, Anthony L. Brown pleaded guilty for a negotiated sentence. He says this was on the advice of his attorney. Today, Anthony is 42 years old. He says at the age of 25, he had no idea how long 40 years could be or what the decision would cost.
In addition to his claim of innocence, Anthony L. Brown claims his rights were violated as he was repeatedly denied due process. He cites a succession of examples of these failures. In the realm of criminal prosecution, these are 2 separate issues. The claim that Brown was denied due process is significantly easier to verify or disprove than his claim of innocence, especially considering the age of the crime. If Anthony L. Brown was denied due process, he may be entitled to a review of his case on those grounds, much in the same way allegations of jury tampering have resulted in an evidentiary hearing for Alex Murdaugh to determine whether or not he should receive a new trial. The question is not about criminal guilt or innocence, but about the judicial process and whether or not the process resulted in a fair trial according to the law. If Anthony L. Brown is an innocent man who's been wrongfully convicted, he's not the only one who's been failed by the system. If he is not the person who pulled the trigger and ended her life, Mrs. Maloney has also been denied justice. To have this claim heard in court, the defendant would likely need to provide compelling new evidence or evidence of wrongful prosecution. Even then, a request for a hearing on the matter could be denied by a judge. and the matter dismissed. If his claims cannot be confirmed or disproved, nothing changes. Anthony L. Brown will remain where he is until April 18, 2044. Even if his claims prove to be true, the odds are solidly against him. The Innocence Project exists because of the lengthy and difficult process involved in the pursuit of justice long overdue. So far, a review of the available documentation raises more questions than answers. Anthony L. Brown calls his case bizarre. It's a word he's heard many times from attorneys who would meet with him, give his papers a once-over, and then slide them back across the table to him before walking away, disinclined to offer representation.
If anything is clear, it is that Anthony and his loved ones see sharing his Innocence Project application with FITSNews as an opportunity to have the case heard in the court of public opinion. It is a risky last resort. It is their hope that telling his story would attract the kind of attention that could lead to change and freedom. They have observed with interest as some of the same individuals involved in Anthony's case made international headlines as characters in the story of Alex Murdaugh. Anthony was indicted by solicitor Randolph Murdaugh and sentenced by Judge Carmen T. Mullen. His post-conviction relief was denied by Judge Perry Buckner. As the once powerful Murdaugh legal dynasty appeared to be losing the influence long held over the criminal justice system in the 14th Circuit, Anthony's people were encouraged by the crumbling of the facade and hoped more would be revealed. They resolved to contact some members of the media covering the Murdaugh saga to ask for coverage of his case.
They have also observed with interest the manner in which Adnan Syed's murder conviction was vacated by the state of Maryland in 2022 after his story was told on the Serial podcast and followed by millions. Yet even this seemingly victorious example is in many respects a cautionary tale. The Serial podcast made a case for Syed's innocence in 2014. Although he was released from prison, the process took 8 long years, and at this point, nothing is guaranteed. The hearing in which Syed's conviction was vacated resulted in an appeal from the victim's family, who say they did not have sufficient notice to participate in the proceedings. The case is headed to the Maryland Supreme Court, and Syed's newfound liberty may not last. Even so, the Adnan Syed story represents the dream, the best-case scenario for prisoners like Anthony who claim innocence and hope to somehow overcome their own bleak circumstances.
There are not many more such examples to call upon. According to the National Exoneration Registry, 2022 was a record year with 238 exonerations. On December 31, 2022, the national prison population was 1,230,100. By those numbers, the odds of an individual being exonerated, no matter how innocent, fall somewhere between the odds of being struck by lightning and the odds of winning the lottery.
In order to investigate the claims asserted in the Innocence Project application for Anthony L. Brown, FITSNews filed FOIA requests with the Walterboro Police Department, Colleton County Sheriff's Office, South Carolina Law Enforcement Division, the 14th Circuit Solicitor's Office, Colleton County Clerk of Court's Office, South Carolina Department of Corrections, and South Carolina Criminal Justice Training Academy. FITSNews also reached out to Brown's defense attorney and co-defendants to request information about the case. The door is open to anyone with knowledge of the circumstances surrounding the crime to contact FITSNews by emailing research@fitsnews.com, on or off the record.
In reporting on criminal activities of any kind, FITSNews always includes a reminder that the accused are considered innocent until proven guilty in a court of law, even after a matter has been adjudicated. FITSNews is always willing to pursue credible claims of innocence. The objective is to fully investigate the claims and follow the truth wherever it may lead.